Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the imposition of the penalty in case of search. In such cases, it has been seen that whenever the search party comes and makes a search on the assessee, then it may happen that due to some pressure, the assessee may admit some income at the time of the search and may accordingly file his return of income. The question arises whether in such cases the penalty is mandatory just because the assessee has admitted that there is some undisclosed income at the time of search and while making the statement under section 132 subsection 4. This issue has been taken up by Chennai I.T.A C bench in the case of Enrica Enterprises Private Limited versus Deputy Commissioner of Income Tax. This case is reported in 125 I.T.A Tribunal at page number 340 and the date of the judgment is 6th March 2024. In the present case, when the search was going on the assessee, some cash was found at the premises of the assessee's director and it was admitted by the assessee that there is some undisclosed income regarding some marketing expenditure, and the assessee admitted that out of that marketing expenditure a disallowance of 1/3 can be made, and accordingly the assessee, while filing the return of income under section 153A, pays tax on this 1/3 disallowance of marketing expenditure. While the assessment order was passed, in that assessment order the assessing officer initiated the penalty against the assessee by writing in the assessment order that there should be initiated a penalty under section 271 AA-B subsection 1A clause A. But at the time of imposing the penalty, when the show cause notice was issued, first of all there was no mention that under which clause of section 271 AA-B subsection 1A the penalty has been proposed on the assessee. In section 271 AA-B subsection 1A, there are two clauses, clause A and B. Clause 1 says that when the assessee admits some income at the time of the search and pays tax on that income, then there would be a penalty of 30% on the assessee, otherwise it will be 60% in clause B. But from the reading of section 271 AA-B subsection 1A and clause A, it is very clear that the penalty can be levied only when some income is relatable to some specified year at the time of making the search or at the time of making the statement by the assessee during the search. But when the assessing officer issued the show cause notice, there was complete non-application of mind by the assessing officer as regarding mentioning the specified year for which that undisclosed income relates. In this case, the tribunal and the assessee was in favor of the judgment, that is I.T.A versus Manjunatha Cotton and Ginning Factory, which is related to 2013 judgment, which is reported in 359 I.T.A at page number 565, in which the penalty was deleted just on the basis of the ground that the show cause notice was not specific about the limb under which the penalty is imposed. In the present case, the show cause notice was not mentioning whether the penalty is under clause A or whether it is under clause B. Further, the tribunal said that in the present case, the penalty is levied on the basis of the addition which is on ad hoc basis, and in the present case, the income of the assessee was not quantified in the statement recorded of the assessee. And when the confirmation was also taken from the supplier in that confirmation the supplier has not admitted anywhere in the statement that some cash has been paid by him to the assessee in respect of expenditure booked. So from the facts of the case, it is very clear that the disallowance was not related to any specified year at the time of the search. So in that case, the penalty is not leviable automatically just because the assessee has admitted some income at the time of the search and at the time of making the statement of the assessee under section 132 subsection 4. Thank you, friends.